Hello, my name's Professor Rick Rawlings. I'm Professor of Public Law here at UCL, and I'm now going to talk about the Judicial Review course which I lead on the UCL LLM. As any public lawyer wherever you're educated would know, Judicial Review is a core subject, and that indeed is the case as well at UCL. And you can take this subject either in its own right or as a very good pairing subject with other offerings in the public law LLM package. Now, I should say two things at the outset. First, this course operates on the basis of this particular jurisdiction of England and Wales. But at the same time, it's designed, I hope, to be attractive not only to students who come from this jurisdiction, but also to students who come from many other countries around the world, whether indeed that is a common law system or a civilian law system. The second main point to make at this stage is that the course is a unique one in that it takes a wide definition of judicial review. So we will be looking in this course not only at common law developments, but also developments under the Human Rights Act of 1998, and also developments relating to European Union law which are litigated in the national courts. The unifying procedural machinery being the fact of the application for judicial review, which is the mechanism in this country whereby all those different types of challenges may be brought. Now, I lead the course. I'm fortunate to share the course a little bit with Tom Hickson, who is one of our leading practitioners at the bar, specialising in judicial review, and Tom will from time to time contribute a firmly practitioner's perspective on some of the materials that we are looking at. I want to emphasise too that I'm a firm believer in student participation, and that those students who decide to take the course will not only have a good opportunity to talk and exchange views in the course of seminars, but also will have the chance to engage in some mini moots that we run during the 2-hour seminars that comprise the course, and also to make individual contributions of 5, 10, 15-minute duration on particular subjects. And in my experience, students in particular from overseas greatly value the opportunity to make this kind of presentation in the English language. Looking then more closely at the course, it is divided into three main parts. The first is what I'll call the overview section, where we are looking at the contribution in terms of judicial review from the three sources which I've described: common law, Human Rights Act and EU law. And this part of the course is designed first to allow those students who have some familiarity with judicial review in this jurisdiction to revise and bring up to date their understanding of the broader landscape. Second, to allow students coming from overseas a good opportunity to become well introduced to the subject. And then third, for all of us, to begin to think about the interconnections, the relationships between these different sources of law as they play out in individual cases. And as I would suggest, this is one of the particular values of this course at UCL. In the second part of the course, we will be looking at the grounds of judicial review. We will be beginning with what famously is called natural justice, or due process, or procedural fairness. So, for example, we will be looking at cases raising the question of whether an individual has received a fair hearing, and at cases considering whether the decision maker was in some way biased or prejudiced against a particular individual. And this part of the course will give us a particular opportunity to explore the connections, the potential for cross-fertilisation between, on the one hand, the common law, and on the other hand, the European Convention on Human Rights, where indeed we'll find some very interesting case law. This part of the course will then focus on substantive review. It will look first, in this part, at the rather limited approach of the common law in this regard, and will then look at the bolder, more interventionist approaches which sometimes have been developed under the rubric of the European Convention on Human Rights and under EU law. We will be looking in particular here at the ground of proportionality. In the third part of the course, we will turn our attention to the structures and processes of judicial review. We will be looking at opportunities to come into court, to obtain documents to support your case, and of course the possible remedies which, should you win your case, the court may be able to grant. This part of the course will end by looking at the impact or otherwise of judicial review litigation on the conduct of government and public administration. Looking then to the literature for the course, we are very fortunate in this course to have access to a rich literature on judicial review. And this is not only about individual cases, individual decisions, but there is a very good theoretical literature on the functions, purposes, constitutional role of judicial review, and indeed its historical development in this and other jurisdictions. And the course will be making close reference to this literature. We'll be looking naturally at textbooks, a periodical literature, and we'll also be trying to make good use of the great development of recent years, blogging, electronic discussion, and all of that. It may not be a great surprise to learn that the chief textbook that we'll be using in the course is a book that I write with Professor Carol Harlow from the London School of Economics, entitled Law and Administration. And we'll be twinning this book with a well-known book by Professor Craig from Oxford University entitled Administrative Law. Turning then to written contributions from students, you'll have the opportunity in this course to submit 2 essays, one in each term, and then of course receive feedback from your professor as to content and style. And in my experience, students coming from overseas find this a particularly valuable opportunity to learn and gain experience in writing about English materials and of course in the English language. As for the examinations, it's a fairly straightforward picture. It's a formal examination at the end of the course in the usual 3-hour format. And I'm pleased to say that over many years we've produced many splendid results from this particular course. So to sum up, this course is a wide-ranging one. It has a firm jurisdictional base in England and Wales, but it's designed to be accessible and enjoyable for students coming from many countries around the world. Each year I seem to get exceptionally strong class of students, and I look forward again very much this year to having another great year in Judicial Review. Thank you.